Hello, folks. I'm Greg Delane of Delane Realty. I've done quite a few shows. The name of my show is Real Estate Q&A with Greg Delane. We decided to combine a few of the different guests that I've had on the show. These are professionals in their fields. This show is with attorneys and their knowledge to help you understand the buying and selling process of real estate. Let's enjoy the show. This show is open to whoever. It has to be real estate involved, but if you are a title person, attorney, you can come on the show. This is an open show. It's not about me, it's about we. Today's guest his name is on the front of the door, and that's so important. My guest is Bruce Bozeman. What documents does a homeowner have to bring to your office if they're selling their house? I deal with a lot of people that have owned the house for 30, 40 years, and then when they decide on their attorney, they don't know where to get what and what to bring to them to start the process.
That's all too often the case. In those transactions we've had with your office, however, we find that the clients are more educated in the process. The things we ask for, the copy of their deed, a copy of their mortgage papers from their prior closing. If they inherited the property, a copy of the death certificates involved. If they have certificates of occupancy, we need those. And in addition, if there are mortgages on the property, we need to have the mortgage number, the name of the mortgage institution, and address. If they've paid off the mortgage, it's extremely important that we get a satisfaction of mortgage. I mean, years ago, Greg, you might have heard of people burning the mortgage.
Yes, the party.
They would sometimes burn the satisfaction of mortgage, and then when they got ready to sell, they couldn't prove they paid off that mortgage they burned. So that satisfaction of mortgage is extremely important.
So today, when down the road, 15, 20 years from now, when my house is paid off, you're saying make a copy of that and then burn a copy of it.
If that's what you want to do, you make sure one is recorded in the county clerk's office.
On today's show, we have an attorney on the show. We're going to talk a little bit about the process of buying a home and selling a home and what the attorney's responsibilities are to the buyer and seller. On my show today, we have Robert W. Shaw. What about elder law? I'm running into some things right now, and there's people, they may have bought the house 40 years ago, it's been paid for 20 years, and they really don't know. Do you deal with a lot of seniors?
Yes, I definitely deal with a lot of seniors, and elder law covers a huge area, but as far as the real estate end of it goes, quite often I deal with putting the house into trust for a senior. And there's a couple different reasons. One reason would be to avoid probate. And I'm sure a lot of people in your audience have heard about how, particularly if they know people in Florida, that everyone has to have a trust and have their house in a trust. Yeah. Well, up here that's really not true. That if you have an immediate family, you can have your assets, including your house, go through probate. And it's not a really complicated process. It really doesn't take that long, and it's not that costly. But where it would be a good idea to put your home into a trust and avoid probate would be where you have no immediate family. Because the surrogates court has a lot of special rules that if you don't have anyone that's at least a first cousin or closer in relationship, then they're going to require a company, usually a genealogical search company, to find every single relative at the same level of generations away from the person that died. And that's a very time-consuming, very expensive process. Because think about it, you probably have relatives through an uncle or an aunt, a very distant cousin that you don't even perhaps know the name of, let alone have had a relationship with.
Wow.
So in those situations, I have done trusts, and the trust will appoint someone as trustee. And when the person dies, that trustee can then distribute all the assets, and you never have to go to a surrogates court. The trustee makes all the distributions and settles the estate. So it's very efficient.
So I would imagine if I didn't know, or not me, but there are people that didn't know that they're the second cousin of, and then they end up getting a document or something being contacted that they're a relative of somebody who passed.
Right.
then if they're not happy with what they think is their portion, they can hold things up. It can become
Oh, definitely. They can bring a contest in the surrogates court to not allow the probate, and try to put in objections that they want. So it can really draw things out and become a problem.
I've heard of things like that when people they're not there when the people were living. They certainly weren't in ICU before their family member passed. They're in another state, and then they show up and they want to.
Right. Yeah, it happens a lot.
Wow.
And that's where someone with some experience too in estate work, it's helpful.
Hey folks, welcome. I am Greg Delane, and I'm happy to have on my show a person that I met about a year ago. The show is very short. I only have professionals on the show, and today I have attorney Ann Panaccio. Hello, Ann. How are you?
Fine, Greg. How are you?
I'm doing just fine. Listen, Ann is with Panaccio and Millar. Frank Millar and Ann Panaccio, they're attorneys. They're here in White Plains. But real quickly, I want to get to Ann and give us a little bit about yourself so we can get started.
Thank you, Greg. Greg, my law firm specializes in bankruptcy law. I've been practicing bankruptcy law for over 20 years. When I graduated from law school in 1991, I had the great opportunity to clerk for a bankruptcy judge. So I learned bankruptcy law from my 2-year clerkship inside and out. After my clerkship ended, I worked in the city at a large New York law firm for about 3 years, and I decided to move up to Westchester, and I formed my own practice in 1996, and I've been focusing on bankruptcy law since that time. In the last 3 years, my practice has been particularly challenging as a result of setbacks in the economy.
What are the types of bankruptcy?
Greg, there are basically 3 types of bankruptcies available to individuals. Chapter 7, Chapter 13, and Chapter 11. Chapter 7 is known as straight discharge. Chapter 7 works best for individuals that don't own a lot of property, that don't have a home, and that don't have a high income.
Okay.
Chapter 7 has limitations on income. In order to qualify for Chapter 7, you have to, the potential debtor has to meet certain income guidelines, median income guidelines for the geographic area where the person resides.
They have to qualify for chapters.
They have to qualify for
Okay.
Chapter 11 on a disposable income basis.
Okay.
So in this geographic area, an individual debtor without any dependents would have to, his or her income would have to really be below $40,000, which is low. So Chapter 7 has limitations. It really works best for people that have credit card debts, medical bills, or business liabilities. And it provides that a debtor could get a discharge from those debts and move on with their financial affairs unburdened by this old debt.
That's Chapter 7. Okay.
Chapter 13 is an alternative to Chapter 7. Chapter 13 was designed by Congress to help individuals who own a home to keep their home. Chapter 13 has evolved from that original congressional enactment to include people that don't qualify for Chapter 7.
Okay.
Chapter 13 is only available to individuals who have liabilities that basically are less than $330,000 on an unsecured level and $1,080,000 on a secured level. So basically, Chapter 13 works for individuals that are that own property, maybe temporarily down on their luck, and have the ability to pay back some of their debts. Another term used to describe Chapter 13 is judicially supervised debt consolidation. So in a Chapter 13, a debtor will consolidate their liabilities and pay their unsecured creditors 10 cents on the dollar, 15 cents on the dollar, or what a fair and reasonable amount would be based upon their income and their household expenditures.
Okay, wait a minute. You said, and that would be between 300,000 and 1,080,000. In that, they have to be in that.
Yes.
Say if I owe 500,000 for my house,
you would qualify for Chapter 13 because the secured debt level, so mortgage would be a secured debt,
yes,
is subject to that $1,080,000 cap. So for people that come in and they may have a mortgage of $1.5 million, which is not unusual in this geographic area,
yes,
they would not qualify for Chapter 13. The alternative for them would be Chapter 11. Chapter 11 is most commonly associated with businesses, business reorganization.
Okay.
But it is also available for higher net worth debtors who have debts that exceed the limitations for Chapter 13. So a homeowner that may own a home that's worth $2.5 million, that owes $1.8 million on it, would be well served by Chapter 11.
Get it. I get it.
Chapter 11 is more labor intensive and costly than Chapter 13. For example, the filing fee alone in a Chapter 11 case is approximately $1,300, where the filing fee in a Chapter 13 is only $300.
Okay.
So the difference in the filing fee is really a prelude to the difference in complexity of the sections.
The information that you have to research and
the labor-intensive nature of it. See, Congress enacted Chapter 13 to help individuals emerge from bankruptcy and be free from their debt, to consolidate their debt and move on with a payment plan. Congress did not enact a similar provision for higher net worth debtors. So higher net worth debtors that may have debt that exceeds the limitations of Chapter 13 are given the ability to file for Chapter 11 relief.
Our mission here on the show is to answer frequently asked questions and to help people who are selling their homes and buying their homes understand the process of real estate. Our guests are experienced professionals in their field, and of course, experience is the difference. You do a lot of immigration, legalization, things of that nature too, don't you?
That is correct. We practice a lot of immigration and naturalization law, and we help a lot of people eventually become U.S. citizens. And in many ways, it's very similar to real estate.
Yeah.
I always say when you buy real estate, you're getting a piece of the rock. And in many ways, becoming a U.S. citizen, that is really the biggest piece of the rock.
Sure. And these are questions emailed to my website. My website is delanerealty.com. I get these questions emailed. I hear these questions all the time when people want to buy a home or are thinking about selling. But today, we have not covered on my show yet condos and co-ops. What is the difference? That's the first question, because people always want to know what's the difference.
Well, that's a very good question, and there are major differences between co-ops and condos. They both are ways of owning real property. However, the difference is, let's take a condominium. With a condominium, you are what is called the fee owner, owner of the property directly. There's a deed in your name that says you are the owner of that condominium space. Now, condominium space may be similar to a one-family house, for example, where you own actual land, and however, it could also be airspace, and your apartment may be on the 10th floor of a building, but yet you own on the deed that airspace where your unit is built. So you own that real estate directly. You can transfer it by executing a deed. You can mortgage that property. It's a hybrid situation because unlike a single-family home, for example, where you own the entire property there, your lot, the land. In a condominium, you generally own in fee title, means you're the owner of your space, whether it's airspace or land space or whatever, but you also own a certain percentage of the common areas. Let's say the building has hallways, has parking areas, has recreation facilities. So you also own a certain percentage of the common areas. And there's a board of managers, and they manage those common areas on behalf of the condominium. A co-op is different. You still own ultimately real property, but very much indirectly, because what you as the owner own, you are a shareholder. You own stock in a corporation, and that corporation owns the real estate, the building, the land, etc. That corporation and the corporation has directors, and that's the board of directors. They manage that building. But by virtue of you as a shareholder owning those shares, you have the right to occupy, to use a certain apartment in that co-op. And now there are differences. Ultimately, you own and occupy a piece, an apartment, a space, etc. But the type of ownership is really the difference. In condo, you own directly via a deed. You pay the taxes directly to the taxing authority. You can sell your unit by executing a deed. You mortgage it. You go to the bank and you mortgage that property.
A good friend, I've known him for a little while. His name is Wayne Martell, and let me just read a little bit about Wayne. Mr. Martell is an attorney, and his office is at 83 Main Street in Elmsford, New York. Mr. Martell has practiced general law in Westchester County for more than 35 years, specializing in all facets of real estate law, estate planning, probate, and tax. He is a 1971 graduate of St. John's University School of Law and is a member of both the New York State Bar Association and the Westchester County Bar Association. Ladies and gentlemen, Wayne Martell.
And how the scam basically, there's several things that they do, but they will tell you the first thing, of course, that you must transfer the property to me or to some third party because their so-called credit rating is better.
They have good credit.
But now you don't own the house anymore, and they tell you, well, you can rent the house and then you can buy back. Well, very often, without knowing all the terms, they make it so onerous that you really can't buy it back.
Yeah.
So you have technically lost the home and you get evicted. So it is important, if someone learns anything today, is that you never should sign anything with anyone until at least you had your attorney review it. They also they point out there are some other organizations which they have not-for-profit counseling agencies that you can contact.
Sure.
You really need to do that because you're not going to read all the fine print. So the law attempts to help you, but you still need to have someone review it because they would they have what's called a 5-day right of rescission. So even if you sign something, you have 5 days for any reason to change your mind. So within that time frame, you need to go and see someone, say, hey, I signed this thing, is it okay?
So if somebody's looking at the show right now and they just signed a stack of papers with some smooth-talking, smart guy that comes in and says, look, it's in my name and you can buy it back. If they're looking at the show right now, they have 5 days.
5 days.
But well, I would say call Wayne Martell right away.
They don't have to call me, but at least call the lawyer who represented you when you bought the property and immediately bring the documents to the lawyer. Let the lawyer review the documents to make sure you haven't signed something which you technically have given away your home.
Wow.
I did want to mention one other thing.
Sure.
You said if I had I had gotten in the mail again. I'm the executor of an estate, so I'm having all the decedent's mail forwarded to me. And another one of those scam letters about we have money overseas that you have to warn people that if just use common sense that if anything sounds too good to be true,
Yes.
it is too good to be true. That and in this particular letter, that again, it's a typical scam. That I have $14 million that I can't get out of the country. I just want your bank account and the account number, name on the account, wire instructions. I'm going to wire you the money, and for your services, I'm going to pay you 20% of the fee. Just rest assured that is a scam. There is no money for you, because then what they do is that say, okay, we're ready to wire the money, but to show good faith, we'd like you just send us a check for $1,500 or $2,000, because after all, we're trusting you with $14 million. The least you could do is trust us. So believe me, do not send the money, because you will lose it. And I have had clients call me. Another client called that money was waiting for them at the Canadian border. And just be very careful with that. It's not true. And they're very sophisticated.
Biggest financial decisions that you'll ever make, well, three of them, there are a lot more, but three of them that I can think of is marriage, children, and buying a home. Now, I've done all three of them. The first two, they really don't come with directions. You learn as you go.